तैयारी में असफलता कोई कमी नहीं है, बल्कि यह बताती है कि आप सही दिशा में आगे बढ़ रहे हैं। डू नॉट फेयर द फेलियर। यही बात हमें डॉक्टर भीमराव अंबेडकर से सीखनी चाहिए। जब उन्होंने भारत का संविधान बनाया, तब उन पर सबसे अधिक आलोचनाएं हुई, सबसे अधिक प्रश्न उठाए गए। लेकिन डॉक्टर बी आर अम्बेडकर ने कहा था, मैं उन लोगों से कभी निराश नहीं होता जो मेरी आलोचना करते हैं। पीपल हु क्रिटिसाइज हिम। क्योंकि आलोचना से ही सुधार का रास्ता निकलता है। आज हम जिस संविधान पर गर्व करते हैं, वह उन्हीं असफलताओं, संघर्षों और आलोचनाओं के बीच तैयार हुआ था। And that is what today's topic of discussion is. We're going to discuss the features of the Indian Constitution as well as the criticism. But before that, let us recapitulate what we have learned in the previous video. In the previous video, we have discussed the Constituent Assembly was grouped into various committees and each was allotted some tasks. One among them was the drafting committee, and we have discussed in length the members of the drafting committee and how long did they work to draft the constitutions and why the constitution was adopted and enacted on 26 November 1949 but completely enforced on 26 January 1950. What are the source of these two dates, and also what were the articles that were enforced on November 26, 1949. So let us move ahead and start discussing the salient features of the Indian Constitution. So before we dwell into the salient features of the Constitution, let us understand what was the status of the Constitution as on 26 January 1950. The Constitution comprises of total 395 articles, which were categorized into 22 parts, and they were total 8 schedules. But in today's scenario, we have seen that there are more than 470 articles, which is now categorized into 25 parts, and the schedules is increased from 8 to 12. This was the status as of 26 January 1950, and this is the status as of now. So, what would be the features of the Constitution? Already we have gone through it, but I will limit to say 4 or 5 features of the Constitution. And as we proceed further with this lecture, during the course of it, you will be automatically developing the understanding of the different other features of the Constitution. The first features that you can note down is the it is the lengthiest constitution, lengthiest written constitution. Constitution. Why it is the lengthiest written constitution? One of the reasons we have already seen, and that reason was the drafting committee that was there, who was majorly responsible for the drafting of the constitution, were majorly dominated by the legal luminaries or the legal people belonging from the advocate or the law background. And so we have discussed in the previous video that this was one of the reasons why we have the lengthiest written constitution. So you can write that dominance by legal luminaries. Where are I? Yes. The other reason for the Indian constitution to be the lengthiest written constitution in the world is its geographical extent. India is a vast country extending north, south, east, west direction, and its diversity, vast diversity. With vast diversity arises large number of problems. Large numbers of problem, I mean to say, is the large varieties of problems, and you have to include those the solution to those problems, and therefore the constitution become lengthy because India is a vast country with vast diversity and with vast classification of problems. To cater the needs of this vast diverse population, the every single point was included in the Indian constitution. The next point for the reason that is the lengthiest written constitution is that the Constitution of India is applicable to whole country. There is a single constitution, single constitution, one book, one law book for the entire nation. There is no such provision that each state will have their own written constitution, as in the case of United States of America. But each state will follow the single rule book, that is the constitution, and therefore to tackle the the need and uh, the uh, the demand of the different states, the constitution was drafted so that it may satiate, it may satisfy, it may fulfill the demands and requirement of all the states. Therefore, a single constitution for the entire country would automatically result in the lengthiest written constitution. So these were the three reasons. One was the dominance by the legal luminaries, then the vast geographical extent and vast diversity of the country, and a single constitution for both the center and the state. This is the first feature of the Indian constitution. The second feature could be the constitution is drawn from various sources. And we have already seen that there were 10 to 11 sources from where the different aspect of the constitution was, the different provision of the constitution was drawn or taken. And the basic structure of the constitution was the copy of the Government of India Act of 1935. Majorly, the structure is based on the Government of India Act of 1935, and other provisions were copied from the Constitution of Great Britain, USA, Weimar, French, etc., Canadian, Japanese, Irish, and that source, the entire source, we have discussed in the last video. Then it is the blend of rigidity and flexibility. It is the blend of rigidity and flexibility. What I mean by this, see, the Constitution itself includes an article, and that article is Article 368, and this provides for the amendment of the Constitution. Amendment of the Constitution. And why do we have a provision for the amendment of the Indian Constitution? Is because the Constitution was drafted in the year 1949 and 50, and in the time to come, that is in future, the aspiration, the demand would be different. So from time to time, to cater the then requirement of the Indian citizen, the constitution was provided for the amendment. And we have seen that the amendment of the constitution, the procedure, was taken from the South African constitution. So the amendment procedure is basically some provisions like could be amended easily, and some provisions are very hard to amend. Now, since the constitution has provided a provision for the amendment, that means that means any part of the constitution can be amended, because there is a provision for the amendment of the constitution. Any part of the constitution can be amended, yes, but the constitution itself provides strict norms for the amendment of the different provisions. Therefore, we say that the constitution is a blend of rigidity and flexibility. Flexibility because it allows for the amendment of the constitution, and rigidity because some of the provision of the constitution, though it allows for the amendment, but the process, the norms that is to be followed for the amendment of that particular provisions of the constitution is hard and difficult. So if you want to amend a constitution, you have to propose for the amendment that I want to change the particular article of the constitution, and then you have to secure the confidence of you have to secure the confidence of the members. Remember, the constitution was framed by the Constitution Assembly. So, in order to amend the constitution, you need to secure the confidence of the members of present assembly. What is the present assembly? We have the parliament. How you are going to secure the confidence of the members of the present assembly? That is what we call as the majority. If there are 10 people in the assembly and 6 of them agrees for the amendment of the constitution, either adding a new article to the constitution or amending the existing article, you have to gain the confidence of the majority of the people of the assembly. So depending upon what could be the possible conditions for seeking this majority, we have different categories of majority, and let us discuss the different categories of majority at this moment. And the first one is the absolute majority. Absolute majority. There are different types of majorities that are being discussed in the constitution. So let us discuss them at this point. Absolute majority means the 50% of the strength, 50% of the capacity of the house. For example, in the current scenario, the total strength of the Lok Sabha is 545, say 543, sorry. Let us assume for simple calculation it is 544. So for absolute majority, the total seats in the Lok Sabha House, whether it is occupied or it is vacant, does not matter. The total strength of the house is 544, and for absolute majority, you require 272, 272 seats, or 272, yes, or 272 members in your favor. So absolute majority basically is required for formation of the government. That means you have to win at least 50% of the total seats in the house to come in majority and form the government. So this is the absolute majority. The another kind of majority is the effective majority. What is effective majority? For example, let's suppose there are 543 total seats in the Lok Sabha, and or let's say in the assembly, and from 543 seats, some seats are not occupied. The members are not occupied. Why? Because their election is being termed as null and void, or they have resigned in between, or they have the member has died. So in case the member resigned or died, or their election is declared null and void, the seats become vacant. So in effective majority, we calculate the effective strength. What is the effective strength? And how do we get to this number, effective strength? Effective strength is nothing but the total number of seat, that is the total seat minus the vacancy that is created. And vacancy may be created by the above reason that we have discussed. So that would be the total number. So for example, in 543, suppose 43 members have vacated their seat due to any of the reason as mentioned above. So total effective strength would be 540. To gain the effective majority, you would require more than 50%, that is 271 seats, or 271 members must vote in your support for a particular, like say, for a particular amendment to happen in the assembly. Or we say that you proposes anything in the assembly and you want that to be approved, then the total number of yes that you would require would be 271. So where do we require such type of effective majority? We have seen that the constitution is a blend of rigid and flexibility. So some part of the constitution can be amended using the simple majority, and some part of the constitution will be amended with special majority. But where do we require this effective majority? So the effective majority is required for the removal of the, just note down, for the removal of the speaker. Now, for the time being, just note it down, and we will understand who is the speaker, deputy speaker of the Lok Sabha, and what is Rajya Sabha. Just for the time being, just note it down. So when we talk about it later, we can refer to this particular lecture. Removal of the speaker or deputy speaker of Lok Sabha, or removal of the vice president or deputy chairman of vice president, which is ex officio chairman of the Rajya Sabha, vice president and deputy chairman of Rajya Sabha. When you have to remove the speaker or the deputy speaker of the Lok Sabha, you have somebody in the assembly will stand up and will propose that we want to remove the speaker of the Lok Sabha. In that case, what kind of majority you require? You require effective majority. That means the 50% of the effective strength of the House must agree to your proposal and must raise your hand in favor of yes, we want to remove the speaker. And if that is the scenario, the speaker will be removed. So we have seen the absolute majority. We have seen the effective majority. Now let us move to the third part of the majority, which is known as the simple majority. So what is the simple majority? Simple majority. Simple majority means 50%, more than 50% of the members of the House, present and voting. There is two important point that is to be noted. Only we are concerned with those members who are present and they participate in voting. For example, there are 543 seats in the Lok Sabha, out of which we have seen that 500 seats are effectively present and 43 are vacated. So in this 500, there are 500 members because effective majority is 500. That means effective strength is 500. So out of this 500, say suppose on any particular day, only 200 members were present. 200 members were present. So among these 200 members who were present on a particular day, let's suppose on a particular topic, 150 members only decided to vote and 50 members abstained from voting because for any particular reason, say they do not want to show their support or do not want to show their denial to a particular proposal, they would say that we would not vote. That is, neither we are in favor of this proposal nor we are in against of this proposal. So the 50 person may or 50 member may abstain from voting. So out of 200, if 50 members abstain from voting, how many members are we left with? 150 members who are ready to vote. Out of this 150, now we require more than 50% to vote in yes. That means out of the total vote, how much vote we require for yes? That is the 76 vote. If 76 member raises their hand in support of the proposal, that proposal will be accepted, and that majority is known as the simple majority. Okay, that majority is known as the simple majority. Now, there is another, and so let us just write a few examples where such type of majority is required. See, we have the election of speaker. So most major of the provisions in the constitutions required simple majority. You see, election of the speaker, deputy speaker of Lok Sabha. Then we have Article 3, Article 2 and Article 3. Then there are certain motions such as the confidence motion, no confidence motion, adjournment motion. Then we have the abolition or creation of legislative council, etc. ठीक है. approval of, I can name few more, such as the resolution disapproving the continuance of the national emergency. For you will see that for implement the national emergency, you require a special majority. But to remove the ongoing emergency, national emergency, only you require is a simple majority. So this is a simple majority. Now let us move to the special majority. What do you mean by the special majority? Special majority means we have more than more than two-third of the members present and voting. So special majority, this is first category. There are basically three categories of the special majority, and this is the first category of the special majority where we are talking about only two-third of the members present and voting. That means in the above case, if there are 200, 150 members who decided to vote, so two-third of it must vote for yes. That means 100 members must vote for yes. In simple majority, we would only require 76 vote, but in special majority of type 1 or first case, we required the 100 yes, 100 votes in your favor. This is the special majority where we required more than two-thirds of the members present and voting, and they should vote in your favor. Okay, more than two-thirds of the members present and voting. In addition to this, and what could be the provision in which you require a special majority? That is the article number say 312. That is creation of new All India services. Creation of new All India services. You require a special majority. That is two-thirds of the member present and voting. So another type of majority could be the special majority type 2, in which the first condition must be fulfilled. That is, you must have two-thirds of the members present and voting, plus you should also have the absolute majority. Now, how these both condition will be satisfied? Let us see that. Absolute majority, where we have seen that 50% of the total membership. That means more than 50% of total membership. Let's say that the total membership is 544. So 50%, more than 50% of that would be 272 effectively for 543. Let's say 543 is the total membership. So the absolute majority, you will require a strength of 272. Now for this 272 must say yes, and this should also satisfy the condition 1, that is must be two-thirds of the members present and voting. So two-thirds of the member means two-thirds of, say, we don't know how many members should be present and vote. Let's say that X be the number of members who should be present and should vote. Then two-thirds of it should vote for yes, and that should be equal to 272. That means that should also fulfill the absolute majority. So that should be 272. So X could be greater than equal to 272 into 3 upon 2. That is 2136. Okay, that is correct. 8, 3 3 is a 9, 1 10, 3 1 3 1 4. That means you see, for absolute majority, how many members do you require? You require 408 members that should be present, and vote. Okay, and this number, you see, the greater the number is, the more difficult it becomes to get a particular proposal to be approved, because it is not like very easy for 408 members to be present, and then out of it 272 members will vote for yes. So this is a bit difficult to achieve each time, and therefore only those provisions which are very essential in nature would require this type of majority, that is special majority category 2, in which there is two-thirds of the members should be present and voting plus absolute majority. So let us see what are those provisions. So that is the removal of judges judges of Supreme Court and High Court. and removal of Comptroller Auditor General and Chief Election Commission. Then, if you want to amend the something in directive principle of the state policy, DPSP, that is part 4 of the Constitution. If you want to amend the part 4 of the Constitution, you would require such a difficult majority. If you want to amend the fundamental right of the Constitution, that is part 3rd of the Constitution, you would require this kind of majority. If you want to impose national emergency also, you will require this type of majority. So I hope you have understood the difference between the special majority category 1 and special majority category 2. In category 1, it was only two-thirds of the members present and voting. That means no matter, there was no restriction on the numbers of the member that is to be present. The only restriction was out of the members who were present, two-thirds must vote for yes. Okay, there was no restriction on how many members should be present. But in category 2, since it has to enforce both this majority, that is the absolute majority plus category 1, so restriction automatically comes for the numbers of members to be present and vote. Now, there is another type of majority under the special category, and that what we call as the third category, in which we require the second category to be satisfied, that is the absolute majority plus the special majority type 1, that is two-thirds of the members should be present and voting, plus we required 50% of the states to agree for that proposal. That is, you must require ratification by 50% of the state. That is, whatever proposal you have done, that you have proposed in the house, if that has received the approval of the house by this majority, that is the category 2, that means 272 members have said yes to your proposal. Again, you have to send that proposal to all the states. And if, say, suppose 24 states are there, if more than 50% of the state, that is 13 state, is also agreed to the proposal, then in that case only the proposal will be accepted. And this type of majority would be very obvious, will be required when you change the federal nature of the constitution. What is the federal nature? We will see in a moment. But if you want to change the federal nature of the constitution, to amend that particular part, you require the special category type 3. Also, you want to change the manner of trade between center of the state, or those provision in which center or state is related, that is the federal characteristic of the constitution is related. For that part, you would require ratification by 50% of the state. Another and the last category of majority is the 50% of the, sorry, two-third of the total membership. See, we have 50% of the total membership, what we call as the absolute majority. But in this category, we have two-third of the total membership. And two-third of the total membership of the house, that means the two-third of the total seat of the house, irrespective of the vacancies or absences. So this type of majority, that is the type 4, is required in the impeachment of the president. When you want to impeach the president of the country, you would require the toughest majority, that is two-third member, that is out of 543, two-third of it must agree. That means 2, 3, for example, say suppose 3 ones are 3, 3 eights are 24, 3 ones are 4. That is 362 members must agree to remove the president, then only it would be removed. So we have seen the different types of majority, and the special majority type 4 is the most difficult to achieve, and that is required for the impeachment of the president. Then we have type 3, in which we required the above condition to be satisfied, that is the in type 2 of the special majority plus ratification by 50% of the state, and required when you want to change the federal nature. Then we have type 2 category of special majority, where you require two-thirds of the members present and voting plus absolute majority as well. So these were the different majority, and now you can easily understand why our constitution is the blend of rigidity and flexibility. Because for different provisions of the constitution, you require different types of majority. Some are very difficult to achieve, while others are very simple to achieve, such as the simple majority. Now, the next feature of the constitution is the federal system. Uh, I shall remove this. Okay. The federal system with unitary base. This point will become more clear when we proceed with the articles of the Constitution. At this point, I would only say that the Constitution in, enforces the provisions where it accepts that the center and state would work together on the same hand. They have clear cut separation of power between the center and the state. That is, the state is empowered to make laws on the state list. The center is empowered to make laws on the state on the center list, and that is the union list. And then we have the clear cut the roles and authorities of the state as well as the center, but they both work in synchronization. This is what is called as the federal system. The more of it we'll discuss when we proceed further. Just note it down that the constitution has a federal system with unitary base. Why we have a unitary base? So unitary base means although the state is free to act, but at the end it has to somewhere or it is somewhere directly or indirectly linked with the center. Why? See, some of the posts the state is free to decide on its own, but some of the post is decided by the center. For example, the appointment of the governor. The state there is own election of the state. The people of the state decide who would be the chief minister. They vote for their MLAs who get selected in the state legislative assemblies. Then they decide who would be chief minister. Then the chief minister is now administered by the governor. That means the governor has an overview about the functioning of the state, but that governor is appointed by the center. That means though you have a federal system, but still you have a unitary base. Okay, so this point will become more clear when we discuss the different provisions or different articles of the constitution. Then we have the parliamentary form of the government as another feature of our constitution. That is the parliamentary form of the government. What do you mean by the parliamentary form of the government? The parliamentary form of the government means that the government is of the people, by the people, and for the people. It is the people who form the government, and the government sits in the parliament. We have two houses, Lok Sabha and Rajya Sabha at the center, and State Legislative Assembly, SLA and SLC, State Legislative Council at the state level, who sits and frame laws for the people. And the members of these assemblies, that is the Lok Sabha and the Rajya Sabha, are directly elected by the for the Lok Sabha, that is the House of the People. The members are elected by the people directly during Lok Sabha election. So the parliamentary form of the government is the government in which we have a separate yet combined body, that is the executive and the legislature. And more often you will be coming across these two terms, that is the executive and the legislature. So let us understand at this point what is executive and what is legislature. See, executive in the parliament, say, let's suppose we have already said that you only require the absolute majority to form the government. So out of 543 seats, you only require 272 seats to form the to government. For example, for any particular party A, it is not possible for any particular party to win all the 543 seats. In such case, there would not be there would be a single party rule, but that is not possible. So out of say suppose 543 seats, a particular party A forms the government and it has like 300 seats. There would be other party B, C, and D, and rest of the seats are won by this. So the remaining of the seats, say 243, are won by the members belonging to the party BCD, out of which some may be independent. So, which party will form the government? That is the party belonging to the members belonging to A, party number A. So, what is the executive? Those members which basically forms the government are called the executive. It is the government. Executive or who? They are the government. What is the legislature? Legislature means the parliament. That is the entire 543 seat members. These all members together constitute what? They constitute the legislature. They constitute the legislature. The laws are being passed by the legislature. These all members will participate in the in the passing of the law, in the framing of the law. They will suggest modification, they will suggest amendment, and we will go entirely how a bill is presented, how it becomes law. That is a separate topic of discussion. But just understand that the law, in framing of the law, the participation from the legislature is required. That is all the members of the parliament. But to enforce that law, to show, to see the implementation of the law, whether it is being implemented, the different functioning, the different organs of the government are working properly. Who is responsible? Only these 300 people who are forming the government. So they are known as the executive. Now, this executive is responsible to the legislature for their act of commission as well as omission. What do I mean by this? For example, these 300 people all together, if any one of them, let's suppose 299, has done nothing wrong, but one of them commits any crime, then the entire executive is responsible to the legislature. That is 445, 43 people. That is the parliament. And if they commit any sin or if they are not working up to the satisfaction of the people, then the legislature may propose no confidence motion. That is, we are no longer confident in running of this government. And then, if this no confidence motion is passed by the legislature, the executive will have to step down. Step down means the government would no longer exist. The government, the head of the government, that is the prime minister, will have to resign. And then the election will be held and new government will be selected. I hope it is clear the difference between the executive and the legislature. So what are the different features of the parliamentary form of the government? That there would be two executive. One is called the nominal executive and one is called the real executive. Nominal executive means in the government there are two head. There are two head. One is the real head and that is the prime minister, and one is the nominal head, that is the president. Okay. Then there is a collective responsibility. Collective responsibility means, so what are the features of the parliamentary form of the government? Number first, there are nominal and real executive. Nominal and real executive. Then there is collective responsibilities. Collective responsibilities, I told you. That means for the act of one, the entire executive is responsible to the Lok Sabha, that is the legislature. And if the Lok Sabha passes a no confidence motion, the government must resign. Then collective responsibility. After this, we have PM as the leader of the government. As leader, we have the majority power government. Okay. So these are the features of the parliamentary form of the government. So we have a responsible government. What are the advantages? Advantages is we have the responsible government. That is, the government is always watched by the legislature. Their act is watched on by the legislature. What are they doing? Whether there is any progress in the country or not. If not, the legislature will ask a question to the executive. What have you done in these years? What are the number of jobs you have offered? So they are responsible and they have to answer. They have to give the details. They have to answer to the legislature. So we have the responsible government. Then we have the flexibility. That means easy to change the government. Then we have the better coordination between the executive and the legislature. Okay, you see, the member of executive is also the member of the legislature. So we have a better coordination between the executive and the legislature. What are the disadvantage? Obviously, in a majority power rule, if the majority loses, you loses the government. The government resigns. That means there is instability. That means instability means there is frequent change in the government if there is no clear majority. Okay, so this is the major disadvantage of the parliamentary form of the government. So I hope it is clear to you what is the parliamentary form of the government, and we have seen the feature of the Indian Constitution. So these were some of the important features of the Indian Constitution, and we will see the other feature of the Indian Constitution as we proceed on this course. So we have seen the lengthiest written Constitution and the reason for it. We have seen that it is drawn from the various sources, and the sources we have already seen. It is a blend of rigidity and flexibility, and the federal system with the unitary base and the parliamentary form of the government. Now, as in the very beginning of the lecture, I have said that Dr. Bhimrao Ambedkar was heavily criticized. So, what were the point on which the criticism was made? The number one is it said that the constitution is drawn from various sources. It says the members of the Constituent Assembly criticized Dr. Bhimrao Ambedkar, saying that the constitution is a copied one and it is not the original constitution. It is a borrowed constitution. So, on the ground of this criticism, that is point number one, borrowed constitution. What did Bhimrao Ambedkar say? See, borrowed constitution means the constitution is not original. So, India became independence in 1947, and the idea of constitution was presented that the India will have a constitution of its own, and that was allowed by the British government by the cabinet mission of 1946. But whether it was the first time that the word constitution came into existence, no, constitution was in existence hundred of years back. That means the constitution is nothing that is to be unique for each country. It is a universal idea, and the universal idea will be same for all the countries. What will make a constitution unique is the suitability of the constitution with the need and demand of the country. That will only make the constitution a unique constitution. Rest of the provision of the constitution, rest of the features, that is the requirement of all the countries. Let's say suppose कि रोटी कपड़ा मकान तो सबको चाहिए, तो अगर कोई रोटी कपड़ा मकान किसी को दे रहा है तो ये किसी का कॉपी नहीं कर रहा है, बल्कि ये एक यूनिवर्सल नीड है जो सबको चाहिए, है ना? अब उसमें आप कुछ मॉडिफिकेशन कर सकते हैं एज पर द रिक्वायरमेंट. सो that was what the Dr. Bhimrao Ambedkar said against this criticism. He said that one likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world. More than 100 years have rolled over when the first written constitution was drafted. It has been followed by many countries, reducing their constitutions to writing. What the scope of the constitution should be has long been settled. That means what would be the scope of the constitution is already settled, that this should be included in the constitution. Similarly, what are the fundamentals of the constitution are recognized all over the world. Given this fact, all constitution in their main provision must look similar. The only new things, if there can be any, in a constitution framed so late in the day, are the variation made to remove the faults and to accommodate it to the needs of the country. India is going to make the constitution very late, hundred of years after the constitution has already existed. So the only thing that could be seen as a new to it is the variation made to remove the existing faults in the constitution and to accommodate it to the needs of the country. The charge of producing a blind copy of the constitution of other country is based, I am sure, on an inadequate study of the constitution. Those people who are saying that the constitution is nothing but a blind copy of the constitution of other country, either they have not gone through the constitution adequately, or they are shooting the arrow in the darkness. So that is what the Ambedkar said on the criticism of the members of the Constituent Assembly who said that the Constitution is not an original one, but it is the borrowed Constitution. The second criticism is obviously the elephantine size, the lengthiest Constitution, that is the elephantine size. Elephantine size means it is so bulky, so huge. That is also one of the criticism. But again, we have seen the reason why the Constitution of India is the lengthiest written constitution, and that is obvious and could not be obviated, could not be avoided. Another criticism that the people, members of the Constituent Assembly highlighted, were that it said that it is nothing but the copy of Government of India Act of 1935. This is not, the constitution is nothing to do in its originality. It is just the copy of 1935 Act. That means you have nothing made anything new. You have not made anything like suiting to the deed, to the demand and the requirement of the country. What you have done is you have copied the Government of India Act of 1935 and presented it as a constitution. Itself, they challenged the sovereignty of the constitution, that it is not the constitution of the thought of the people of the India, but what the Britishers have thought. So the Government of India Act 1935, we see it is itself in itself is the lengthiest act. And what Dr. Bhimrao Ambedkar said, he said that I am not sorry to say that most of the provisions of the Constitution of India matches with the Government of India Act of 1935, but it is only the administrative part, how the administration should be done, only that part has been copied from the 1935. And I am not sorry for this, but I'm sorry that we could not uniquely develop the administration strategies for our country. And so we have to copy it from the Government of India Act of 1935. So he said, um, for example, Srinivasan observed that the Indian Constitution is both in language and in substance a copy of the Government of India Act of 1935. To that, Dr. Bhimrao Ambedkar said that the criticism in the Constituent Assembly as to the acquisition that the draft constitution has reproduced a good part of the provisions of the Government of India Act of 1935. I make no apologies. When many members, including CP have N. Srinivasan and Sir Ivor Jennings, who said that it is the constitution he derived from the Government of India Act of 1935, Ambedkar said that I make no apologies. I am not sorry for it. There is nothing to be ashamed of in borrowing. It involves no plagiarism. There is no plagiarism. That is, I've made no crime. That is because the Government of India Act of 1935 is not a patent of someone. I have not copied it and made a crime. Yes, I have copied it and there is no shame in it. It does not involve plagiarism because nobody holds the patent to the fundamental idea of the Constitution. The fundamental idea of the Constitution is universal. So what I am sorry about is that the provisions taken from the Government of India Act 1935 relate to the relate mostly to the details of administration. Okay. So this is what the Dr. Bhimrao Ambedkar said on the acquisition made to him in regard that the constitution is nothing but the copy of Government of India Act of 1935. Another criticism that we see is the constitution is considered as the not a common man book, but it is considered as the paradise of lawyer. And that was an obvious criticism because we have already seen and we have mentioned so many times that the constitution, the drafting committee was dominated by the members who had the legal background. Okay, so the point that the members of the Constituent Assembly said that they are the constitution is the paradise of the lawyer. Sometimes or to some extent justify it. And who termed this the lawyer's paradise? The constitution is the lawyer paradise. It was termed by the Sir Ivor Jennings. Okay, they opined that the legal language and phraseology adopted in the Constitution make it a complex document. A normal man with a normal English literature knowledge not be able to understand it in its entirety because the languages and the terms and the phrases that has been used are mostly leaning towards the legalistic and complicacy, and therefore it is a complex document. Another criticism that was made by the members of the Constituent Assembly is that it is not a Gandhian constitution, it is an Gandhian constitution. What do you mean by the un-Gandhian constitution? First of all, you should recall at this point that the Gandhi was not, Mr. Gandhiji was not the member of the Constituent Assembly. And many of the members of the Constituent Assembly said it is not the constitution that fulfills the dream of the Gandhi, a dream in which Gandhi saw the villages flourishing, developing, industries being set up near the villages. The constitution does not fulfill that dreams of Gandhi. And there was no talk about the Panchayati Raj and the district panchayat and the village panchayat. However, this criticism was at this moment does not hold valid because we have already amendment made to the constitution where we have inserted schedule 10, 11 and 12 in which we are talking in detail with the powers and the roles of the gram panchayat and the municipal corporation. So this is all we have to deal with the features of the Indian constitution, and we have seen the criticism of the makers of the constitution and the reply that was made by the Dr. Bhimrao Ambedkar. Now, next, let us see what are the different parts and schedules of the constitution. In the very beginning, I told you that the original constitution had only 395 articles categorized into 22 parts and 8 schedules were there. But as of now, we would see that there are 25 parts of the constitution and more than 470 articles are there, and the 12 8 schedules were now improved, means amended, and 9, 10, 11, 12, 4 more schedules were added. So it is important for you to remember the schedules. That is, the first schedule talks about the states and union territories. And second schedule talks about the salary, allowances, privileges of the president, governors, judges, etc. The third schedule talk about the forms and our oaths of affirmation. Fourth schedule talk about the allocation of seats in the Rajya Sabha. See, the schedule one, wherein we are talking about the states and union territories, and the schedule four are related. Whenever you are making any changes to schedule one, schedule four will automatically get affected. Why? Because it's talk about the allocation of seats in the Rajya Sabha. If you're making new states or new union territories, and then you have to allocate the seats of that state in the Rajya Sabha. So making any changes in the schedule 1 will automatically invite change in schedule 4. Then we have schedule 5 where we are talking about the administration and control of the scheduled areas and scheduled tribe. Then we have schedule 6, administration of tribal areas in Assam, Meghalaya, Tripura and Mizoram. Remember, there are 4 states only for where we are talking about the administration of tribal areas, and we will discuss this at large when we move to the schedule 6, that is the states are Assam, Meghalaya, Tripura, and Mizoram. Then in schedule 7, we have the unions, that is the distribution of the subjects, that is in the union list, state list, and concurrent list. Schedule 8 talk about the recognized official languages, that are 22 in count as of now. Then we have the ninth schedule, 10th schedule, 11th schedules, and 12th schedule. These were added later to the constitution after amendment. And 9 schedules talk about the laws protected from the judicial review, mainly the land reforms. 10th schedule talk about anti-defection law. The 11th schedule talk about the powers and responsibilities of panchayat. And the last schedule, that is the 12th schedule, talk about the powers and responsibility of the municipality. You should learn these schedules by heart. It is not going to be asked in this UPSC examination, but be sure in the state examination, one question is expected from it, and you should remember this. Also, there is a list of all the 25 parts of the Constitution. We will proceed one by one, all the parts. We will see the articles in part 1, that is the Union and the Territory, part 2, that is the citizenship. Then we will move on further with this particle, with this part and different articles in it when we move further with this lecture. So all this part, including from part 1 up to part 25, is already will be covered. We will try to discuss the details from up to part number 6, and then you see the part 7 is already repealed related to part B states. So part 7 is already repealed. There is no part 7 in it. And see that the other part, that is part 4A, that is the fundamental duties, were amended and added. Part 9, wherein we are talking about the panchayat. Part 9A, where we're talking about the municipalities. And part 9B, where we're talking about the cooperative societies, are amended and added to the constitution. So we will move further as the course of the lecture proceeds, and we will discuss each part. The first we will start with the union and its territory, that is part 1, and we will see different articles in it, and accordingly we will proceed. You should go through all this part as of now, and then just try to remember some of it. That is part 15 talks about the election, part 14A talks about the tribunal, then part 18 talks about the emergency provisions. Part 14 would talk about the civil service examination, that is service under the union and the state. And so up to part 10, you should also remember the schedule area and tribal area. Part 9B, cooperative society, 9A, municipalities, 9 panchayat, 8 is union territories. Part 7, no need to remember because it is a field. Part 4, directive principle of the state policy. 4A, fundamental duties. Part 5, union. Part 6, state. So these you can remember. You have the union, you have the states, and you have the UT. And this you will automatically remember when we will proceed with the further. That is union and territories, citizenship, fundamental right, DPSP, and fundamental duties. Then you have the union states and UT, and then this part as panchayat, municipalities, cooperative society, and scheduled and tribal areas. So, but up to part 10, it is very easy to remember. So here we have shown what were the added part that we have already discussed and what will be the added schedule that also we have already discussed. If you want to remember the year, you can remember in which year each parts and each schedule were added and what was the amendment. That is the ninth schedule was added by first amendment and the 10th schedule by 52nd amendment, 11th schedule 73rd amendment and 12th schedule by 74th amendment. And just this you should remember. And also, this is directly linked that we've seen in the 11th schedule and 12th schedule, that is the 73rd and 74th amendment, where 11th schedule talk about the municipalities, panchayats, and 12th schedule talk about the municipalities. So we have seen that the part 9 is talking about the panchayat and part 9 is talking about the municipalities. So obviously, here we have part 9 as the 73rd amendment and part 9A as the 74th amendment relating to what we have seen in this schedule, 73rd Amendment and 74th Amendment. So, moving forward, let us now discuss the very important and the first page of the Constitution, that is the preamble. Or let us stop here today. In the upcoming video, we are going to start with the first page of the Constitution, that is the introduction of the Constitution, that is the preamble, and we will see what are the different terms used in the preamble. And up till this point, we have completed the background of the Constitution, the detail of the Constituent Assembly, and the overview of the Constitution. Now we will dwell into the preamble and then from there onward we will start taking article number 1 and proceed with the rest of the articles of the Constitution. So thank you and I appreciate your patience in listening to me. I hope you enjoyed the video. Give me a thumbs up if you like this video and share your feedback in the comment.